Good morning, everyone. Thank you for joining. My name is Christy McKenzie. I am the Assistant Coordinator of Neighborhood Services here in the Department of Senior Services for Erie County. I'd like to welcome you all to our 2020 Virtual Elder Law Day Summer Series. This series will continue to run through every Wednesday through the end of this month, September. Please visit our website at erie.gov/ELD to sign up for upcoming sessions. A few things to mention: this presentation is being recorded, so the presentation and the slides that are available today will also be available on our website at a later date for you to review. Feel free to ask questions during our session using our Q&A panel to the right-hand side, although we ask that you refrain from inserting any personal information into those questions. I would like to take a minute to thank all those individuals who have helped to make this summer series possible. Our county executive, Mark Polenkars, Kara Nicholson, the CEO for the Center for Elder Law and Justice, and of course, our Senior Services Commissioner, David Shank. Please allow me to introduce our guest speaker today, Kelly Gusmano. Kelly is an associate at Woods, Oviatt, Gilman in their Family Wealth and Estate Planning Department. She concentrates her practice in the area of elder law, long-term care planning, and Medicaid. Ms. Gusmano is also a member of the National Association of Elder Law Attorneys. Welcome, Kelly.
Hey, I'm hoping you can see me now.
We can.
Okay, perfect. Hello, everybody. Thank you so much for watching our webinar today. I've done a few webinars now virtually, still adjusting. It's still a little strange, so just bear with me. If you have any questions during the presentation, please feel free to use the Q&A chat. I will try to fold those questions in as we go along. If I don't answer your question right away, let me know, or we'll save it for the end, okay? So I'm happy to make this a bit of a discussion. Might be challenging given the virtual nature, but we'll see how that goes. All right, can everybody see my screen, Christine?
Yes.
Okay, perfect. I control it, that's the question. There we go. So today I'm going to be presenting on chronic care Medicaid. Medicaid is a health insurance that is provided by the government. It pays for many different things. In today's context, we're just going to be talking about what it covers for nursing homes, particularly room and board, and how you could obtain that coverage even if you've done prior planning. I want to start off, however, by just reviewing the documents that everybody should have. It is imperative that you have your wishes laid out ahead of time, regardless of whether you're going to use Medicaid or not use Medicaid. Everybody should have a last will and testament. Everybody should have a power of attorney. Everybody should have a living will and healthcare proxy for making healthcare decisions. And of course, your wishes should align with your beneficiary designations. And this is so important because you can have the best of intentions, but unless those are laid out in specific documents, they're not going to be carried out. And unless you've appointed trusted people to carry out your wishes, those aren't going to come true. I've highlighted the POA in here specifically for a few reasons. You could have the best laid out will, and you can make sure that your beneficiary designations match those wishes as stated in your will. However, circumstances can change, and we're actually going to be covering a lot about how those circumstances can change. And that is why it is imperative that you've appointed somebody that you trust to make sure that your wishes continue to be carried out as changes are potentially being made to your finances, maybe to become eligible for Medicaid. So everybody should have that power of attorney with the statutory gifts rider, which would allow your agent to transfer your assets around if need be. And again, we'll cover that. Now, as I said before, you could have your plans laid out. You could have this account going to your daughter, that account going to your son. But if all of a sudden things change and you find yourself needing nursing home care, it can be, unfortunately, very, very expensive. So what you could be looking at is having to deplete certain assets to pay for your care. And that's definitely not something we want to do, but we want to be able to adapt if necessary. Long-term care costs, especially nursing home care, can cost a lot. So can assisted living facilities, so can in-home aids. And we want to just make sure that all along your wishes are being carried out, even if you're not the one carrying out your wishes. So nursing homes right now in New York State are very expensive, almost insanely expensive. It can range anywhere from $12,000 per month to $17,000 per month. There's actually a nursing home here in the Rochester area where I am that costs almost about $20,000 a month. Granted, it's for a particular program, but it's almost out of the reach for anybody. Even somebody who has a little bit of money, it's going to be gone in just a few short months. However, there could be circumstances in which nursing home care is unavoidable. Nobody plans on going into a nursing home, but unfortunately, we see many times that it just does happen, or that you can't be safe elsewhere. Obviously, your family is going to want to make sure that you're safe where you are, and that could mean having to go to a nursing home and then looking at these costs. The question on everybody's mind, how do I pay for all of this? There are a few different options. Depending on your financial circumstances, depending on family makeup, depending upon what planning you have engaged in thus far. Medicare, which everybody over age 65 has, will pay for short-term rehab. If you go into a hospital, then you go into a nursing home, you could get some coverage for that room and board care. Typically, that coverage under Medicare is going to last for 100 days. After day 20, there's usually a copay, unless you have a really good supplemental insurance plan that picks up the copay. But for days 21 to 100, you're probably looking at a copay of about $170 a day. That's great. It's certainly more affordable, but Medicare rehab coverage could end at any point in time if the rehab team determines that you're no longer, not that you're no longer progressing, although a lot of nursing homes use that standard. If they determine that you no longer are benefiting from or need skilled rehab services, they're going to cut your Medicare coverage. Okay, well, if you're not ready to go home, what does that mean? Privately paying for your care, which is what you're switched to after the Medicaid coverage ends, or Medicare coverage ends, could cost you about $180,000 per year. That's on just $15,000 per month. Anybody who has any sort of money, it's going to go very, very quickly. And those are the lucky ones. If you have nothing, how are you going to pay for this care? It might be that you have long-term care insurance. For some, long-term care insurance is great if they have assets that they're seeking to protect. However, it's very expensive. Premiums can be quite pricey. And it's certainly a policy that you should have gotten probably in your 60s or 70s. It's really, really expensive to obtain coverage after that. Not to mention long-term care insurance coverage doesn't necessarily cover the full private pay rate either. So then you're going to have to be looking at, okay, well, still, how do I afford this? So what we look at doing is adding or substituting Medicaid. Now, Medicaid is a program that we've all paid into. We all pay into Medicare and Medicaid. And it's my firm belief that nobody should have to be impoverished for their health care. I would hope that many of you share that belief. And it does provide substantial savings. A lot of our clients who are looking to potentially protect some of their hard-earned assets that they've worked their whole life to gain and possibly pass on to their children, they can have a nursing home bill go from $15,000 a month to $1,000 or $2,000 a month. The amount that you pay to a nursing home once you're on Medicaid depends upon your monthly income. And we can cover this more in just a little bit. But if your monthly income is $1,500 from Social Security, well, then once you're on Medicaid, you can get on Medicaid, your bill then going forward is going to be $1,500. It will change, it will increase, it will decrease based on whatever your income is, and thus is affordable in perpetuity. Medicaid is, however, a means-tested program, chronic care Medicaid at least. There is Medicaid coverage, or some people might have heard of the New York State Marketplace. That is also Medicaid coverage. It's for those who aren't also eligible for Medicare, typically younger individuals who don't have any disabilities, just have really low income. That Medicaid's income base, we're not really going to focus on that today. Medicaid that we're concerned about that is going to cover your nursing home room and board has a resource limit. So if you have less than $15,750, your name, you're going to be considered eligible. Now, what does this include? This would include bank accounts, stocks, bonds, mutual funds, non-qualified investments. If you have life insurance, it's going to include that cash value. And more or less any other asset you can think of. It doesn't include essential personal property, anything like that, but anything that you can really put a dollar value to. Some of the big ones, though, that it does not include that may have substantial dollar values is your house and any adjoining property. It does not include life estate. So if you only have an interest in your house for the rest of your life, that does not count as an asset. A vehicle doesn't count as an asset, provided that that one vehicle is in use. If you have a second vehicle, that does count. Retirement funds, and that's the biggie, retirement funds don't count towards that $15,750. I've had several people come to me and say that we don't qualify for Medicaid. Mom or dad has $400,000 in a retirement account. And what I tell them is, great, that's good news. That's what I want to hear. Most of that will be protected. If that, so long as that fund is distributing money as the IRS requires, that fund is going to be considered exempt. Medicaid will count the income that's generated from the account, but that's a little bit different. Again, that will go towards what you're going to pay to the nursing home going forward. But the balance of those retirement funds, IRAs, 401ks, 403bs, are all going to be exempt for Medicaid purposes. There's a lot of changes to Medicaid lately. That has not been one of the changes that have been suggested. I don't see that happening anytime soon. So fingers crossed, retirement funds are exempt now and in the future. Prepaid burial accounts also do not count as an asset. So if you have, let's say you're about to go into a nursing home and you have about $25,000 in total assets. Well, I may recommend, okay, let's get you eligible for Medicaid. You can do that two ways. You can either spend that remaining $10,000 on the nursing home and become eligible, or you could put that $10,000 into a pre-need burial account. These are accounts that can be set up at any funeral home. You go in, you say, I'm going to be applying for Medicaid. I need you to make my account irrevocable. So once I give that money to the funeral home, I can't get it back. As long as you do that, that money is tucked away. It does not count as an asset for Medicaid purposes, and you've taken care of a big unfortunate expense that your loved ones won't have to worry about. So there is the resource limit. On this income side, there's no strict income limit. If you recall, the monthly payment to the nursing home going forward is going to be based off of your income. The higher your income, the higher your monthly payment to the nursing home. Really, the only hard and fast rule is that your income can't be higher than the private pay rate at the nursing home. Otherwise, you're not going to qualify for coverage, and you'll just have to pay your bill going forward. So I had a question come in that I want to address here, and it's a very good question. One of the participants is wondering whether Medicaid would put a lien against a house. So that, as is everything in Medicaid, is a rather tricky question. It depends, which is not what you're going to want to hear. So long as you apply for Medicaid and you have a house, if you have an intent to return, that house is going to be deemed an exempt asset. Okay, so you can get Medicaid. They won't put a lien against the house while you're on Medicaid in most circumstances. What they will do, however, is if you pass away with that house still in your name, Medicaid could seek to recover against the assets that are left in your estate. So if you have more than a life estate, if you have the entire value of the house left in your estate when you pass away, Medicaid will make a claim on that asset, okay, to pay itself back for everything that is paid on your behalf. That is oftentimes why, even though you can have a house and apply for Medicaid, we like to do planning to protect that asset, not just at the initial application phase, but at the point where if you were to pass away, we want to make sure that's not in your name, okay? In some circumstances, Medicaid will put a lien against the house. I've only ever had it happen once. It's very, very uncommon, but it can happen. And so I just want to kind of put that out there. If you apply for Medicaid, you say, it's just a very clear statement. If I were able to return home, I would return home. Your house is exempt. If the county determines that you're medically incapable of ever returning home, they could decide to put a lien on the house. Now, they have to prove that you're unable to do so, but they could, okay? Generally speaking, a house is exempt. We always talk about it as part of the planning process because there's a million and one things that we can do to protect the house, and we're going to do them if we can, okay? A spouse's, one more question before we move on. There's a question as to whether a spouse's bank account would count when considering eligibility. Typically, well, number one, yes. However, there's a plan that we typically engage in called a spousal refusal plan, where we say this money belongs to the spouse only, and the spouse is refusing to contribute his or her assets to the Medicaid applicant's care. That will kind of wall off the spouse's investments to some extent. The county would have some right of recovery, but we're going to get to that in just a bit. Okay. Good question so far. Thank you. All right. So I'm sure what's on everybody's mind and what often comes up is, what does this mean for the 5-year look back? Everybody seems to know about this 5-year window in which case you can't give away any assets and still be considered eligible for Medicaid. Kind of how it works. So when you submit a Medicaid application in a post-COVID world and pre-COVID world, right now they're not actually reviewing documentation. The county, which administers the Medicaid program, the Department of Social Services, will look through 60 months worth of bank statements. So that's 5 years worth of bank statements. They are looking to see if you gave away any assets in the past 5 years that you could have otherwise used to privately pay for your care. In Erie County right now, for every $10,720 that is gifted in the past 5 years, Medicaid will say, okay, you're ineligible for Medicaid for 1 month. Now, what does that mean? That means you have to come up with a way to privately pay the nursing home bill during that 1 month. That being said, it's not true that it's ever too late. I know there's some double negatives there. That means even on the eve of somebody going into a nursing home, you can still engage in strategies to preserve assets. Even if there's gifts, there's things we could do to maybe undo the gifts. We also might make gifting part of our plan, but we're going to make sure that you have the funds to cover during a penalty period. There is a question that just came in that I am going to save to the end because there are some changes that are coming to Medicaid, or actually were already enacted. Most of them have to do with home care, and I will touch on that briefly at the end because I think it's important to cover. And to point out that Medicaid covers not only nursing home care, but in-home aid. So I'm going to, please, if I don't get back to that question, please bring that up again at the end. Part of the planning for that 5-year look back, again, even if you're about to go into a nursing home or have already been in a nursing home for a few months, we will try to see, are there any transfers that you already made that we could say that was exempt, that should not be penalized against you, or that we could now transfer to try to protect, and we will try to do so to maybe a spouse. Transfers to spouses are exempt transfers. When we talk about that spousal refusal plan that I get to in a second, that takes advantage of the fact that transfers to spouses are exempt. Even if we did do some gifting in the 5-year look back or plan on doing some gifting, we can still become eligible for Medicaid. It's still an option. So we call this time period crisis planning. You can do advanced planning to become eligible for Medicaid. We call it asset protection planning. It's a large part of our practice. If you or your parents are about to be looking at long-term care options or starting to think about long-term care options, there's things that we can do and things that we could put in place to make sure that your assets are protected with the intention of applying for Medicaid more than 5 years from now. So we can do asset protection planning or preemptive planning, and that's one thing. What we're going to focus on is the crisis planning. Mom or dad is going into a nursing home. I'm going into a nursing home. Mom or dad has been in a nursing home for 5 or 6 months, and we've been privately paying. What are our options? Okay. And it largely depends on 2 different scenarios. Is the Medicaid applicant married, or is the Medicaid applicant single? Our plan, again, to the extent possible, tries to take advantage of exempt transfers. We can save a lot more by transferring assets to a spouse when there is a spouse. So if we have a single client, our options are a little bit more limited, but we can still save substantial assets. So I'm going to walk you through a few of those scenarios. In the spousal refusal plan, this is a technique we use for an individual who comes to us who needs Medicaid, who has done no prior planning, and hopefully has done no prior gifting either. In this circumstance, what we're going to do is take John Doe's. He's the one who's in the nursing home. He's considered an institutionalized spouse per the Medicaid terms. His wife, Jane Doe, is considered the community spouse. Again, these are fancy Medicaid terms. We're going to take all of John Doe's assets, this $100,000, and transfer it all to Jane. Now, if we think back to our Medicaid eligibility rules, if John has now transferred all of his money over to Jane, he then has less than $15,750. He is then considered eligible for Medicaid. Now, the spouse's assets are counted. A spouse is allowed to retain certain resources as well. There is a spousal resource allowance. However, for this spousal refusal plan, what we do is we have the spouse sign a spousal refusal, which says that I am not going to use any of my assets to pay for my spouse's care. It sounds unkind. It's just a technique that we use. What that does is that walls off Jane's assets. Jane can now have $200,000. It's over what she's allowed to have, but she has signed that spousal refusal saying she's not going to use any of her resources to contribute to John's care. John, therefore, has less than $15,750. He is considered eligible for Medicaid. Now, this does two things that are important. It automatically opens John to Medicaid coverage. He can apply for Medicaid. He will be approved. We will tell the county that we signed the spousal refusal, and they will approve his Medicaid. His nursing home bill, again, will go from the private pay rate, $15,000, $16,000, $17,000 a month, down to whatever his income is, okay? However, by signing the spousal refusal, what we're also doing is giving the county a right to seek reimbursement from the community spouse, from Jane in this situation. Now, the county can say one of two things. They can say, Jane, I want you to contribute your excess income to John's care. John's going to be paying for his care, but if you have income over $3,160, or no, sorry, they just changed it last year, $3,216.50. Why it's that random, I don't know. If you have income in excess of that, you're going to have to contribute a quarter of that income to John's care. You can say yes, we can say no. Obviously, there's benefits or pitfalls to doing either of those options. Medicaid could also say, okay, Jane, we see that you have excess resources, and technically, if you had used those resources to pay for John's care, we would not have expended the money that we expended. So we're going to seek contribution from you. And that might be an option. Some counties are more aggressive than others. In Monroe County, we typically will do the spousal refusal plan, and the county does not seek any sort of contribution from the spouse. Right now, we're rather lucky in that regard. There's a reason why it's still more beneficial, even if they do. I think in Erie County and Genesee County, Niagara and some of the more western counties are a little bit more aggressive in recovering what they rightfully do. So what they could do is seek reimbursement for their expenditures from that spouse. Now, I have this chart here on this page, and I will certainly share a copy of these slides with everybody. When Medicaid pays for care at a nursing home, they're not paying the nursing home $15,000 a month. They have their own Medicaid reimbursement rates. So let's say client is at nursing home A. Nursing home A has a private pay rate of $15,000, but a Medicaid reimbursement rate of only $7,000. Okay. That means that if I, as the Medicaid recipient, and paying $2,000 towards my care, their Medicaid reimbursement rate's only $7,000, so the county is then paying the extra $5,000 so they can get that total Medicaid reimbursement rate. So obviously they prefer people on private pay in most circumstances as opposed to Medicaid because they are getting more money. But what that means for the community spouse is that they don't have to pay back the full $15,000 to the county because they didn't pay that much towards their care. They only have to pay back what the county paid out. So in this circumstance, it would have been $5,000. So even if they do, even if you're in a county that is more aggressive in seeking contribution from the spouse, you've still reduced your monthly bill from $15,000 down to $7,000, which is more than cut it in half. So it's still a good plan, even if you are in a county that is more aggressive. You can actually do even better though. So on my next scenario, I have what we call an income stream plan. And again, these are rather complicated, and I don't expect everybody to know what to do or obviously do this on their own going forward. I just want to kind of introduce everybody to the options. There are some that you may feel more comfortable with, some that may make you nervous, but there are options there. There are options to preserve assets. And you know, that money walks out the door rather quickly. The more we can do, the quicker we can do, the more assets we can protect. So there's also this income stream plan. Same scenario. Jane now has $200,000 to her name. She got all of John's assets too. Okay. And you know, I do want to just cover one more thing real quick, actually, before we go on. In this scenario, where Jane had $100,000, John had $100,000, it might be that he also has a $300,000 IRA. The plan, the spousal refusal plan stays the same, but we leave John with his $300,000 IRA because it does not count as an asset for eligibility purposes. Okay. So, you know, I don't expect this to be $100,000 sitting in the bank and that everybody has just $100,000 sitting there in the bank. Assets are everywhere. Whatever assets we can consider exempt are going to stay with John. It's the assets that count. Those bank accounts, stocks, bonds, mutual funds are going to shift over to Jane. In the income stream plan, Jane now has $200,000 sitting in her name. Recall, as I said before, that the community spouse is also allowed a resource allowance. The applicant can have $15,750. The community spouse is allowed to retain, it's a range, but on the lower end, the more common end is $74,820. So what Jane can then do to make sure that she's eligible for his coverage too, that they are eligible together as a couple, is to loan her excess resources to a trusted child. So this may mean making a loan of, and again, I just did simple math, 200 minus 74,820, making a loan of $125,000 to Jane's daughter. Okay. This takes the excess resource, converts it into a stream of income. Now remember, there is no strict income limit. This will raise Jane's income for Medicaid purposes, okay? But what it does, and the benefit of doing this plan, is that Jane is no longer considered as having excess resources. She may still want to contribute a small portion of her income to John's care if necessary, but the county can never go after her and seek contribution or repayment for paying towards John's care. Because they were eligible together as a couple, there was no spousal refusal. She agreed to pay what was due, and that excess resources that she had was converted into a stream of income. She's getting it back. They're on Medicaid with no means of recovery. This is a good strategy in those more aggressive counties, and we take advantage of it rather often. Whoa, hold on just a second. And okay, I just want to do a quick recap through those slides. Okay. So that spousal refusal plan and that income stream plan are kind of go-tos if there is a spouse that is still living in the community. Why? Because we can transfer all of the assets to the healthy spouse, the community spouse, and then apply for Medicaid. We tell the county we transferred those assets. They say, okay, those transfers were exempt, no penalty. You can go on Medicaid, okay? However, when we have a single individual, either because they were never married, spouse passed away, there was a divorce, we can no longer take advantage of the ability to transfer assets to a spouse and have that being an exempt transfer. So our options are more limited at that point. They're never eliminated. There's still a lot of things we can do. One of the things we will look at first is whether or not there was any disabled child, any child receiving SSI or some sort of disability payments. You're allowed to transfer all of your assets to a disabled child, maybe a trust for a disabled child, and be considered eligible right away. Then that money is available for the disabled child and their needs going forward. We might also, again, obviously check to see if your wealth is invested in exempt assets. Is it that you have a retirement account or that you have other big dollar figure exempt assets are there? A really nice BMW. I'm just kidding. Anything else that's exempt for Medicaid purposes. For the resources that are not considered exempt. So again, you have 400,000 in an IRA. Let's say you have 1,000 cash sitting in your bank account. We can protect half of those countable funds. And it's kind of a very intricate and tricky way that we do this. So please ask questions if you get a little bit lost. So let's say John, in this scenario, has $100,000. Jane has already passed away. What can he do to protect at least some of that to leave to the kids? Okay. What John can do is take advantage of what we call a gift and note plan. Now remember, if you transfer assets within the last five years before applying for Medicaid, you will be penalized. In this scenario, we are intentionally creating a gift and giving you means to pay through the resulting penalty. So let's just use easy numbers here. John transfers $50,000 to his kids, or to his beneficiaries that he has named under his will. He's laid out who he wants this money to go to. He gifts that $50,000 right before going into a nursing home, when he's already in a nursing home and looking to go on Medicaid. We also take the remaining $50,000 that he has and we loan it to a child. The child will sign a promissory note. That's the note part of the gift and note plan, and promise to pay that amount back to dad. Okay. We calculate these numbers very carefully. How much are we going to gift and how much has to be part of this loan? The reason being is as soon as we apply for Medicaid, which we can do now that John has gifted away his $100,000 of countable assets, he has less than $15,750. And he's considered eligible for Medicaid. So we apply, we say, yep, we gifted away $50,000 to our kids. And they might say, well, when did you gift it? And we'll say, yesterday, we gifted $50,000. And they say, rightly so, okay, well, then we're going to penalize you for about 5 months. 50,000 divided by 10,720. Let's just use easy numbers. So they say for 5 months, we're not going to cover your Medicaid care. You're on your own. See ya in 5 months. Okay. What we have done, however, is we've given you enough money in this loan that we've loaned to a child so that over the course of the 5 months that you have to privately pay, you're getting your Social Security, you're getting your pension income for that month, plus you're getting 1/5 of that loan. We calculate it so that that loan income will afford the private pay rate at the nursing home for that month. So again, I'm going to butcher the math on this one, but let's just say your nursing home bill is $15,000, your Social Security and pension are $2,000 together. Your note will calculate it to give you $13,000 for the month. I know that math doesn't work out, but needless to say, you're going to have enough money to privately pay the nursing home. After 5 months has elapsed, you're through your penalty period. Now that means that Medicaid will then cover your nursing home room and board going forward. Your monthly payment to the nursing home will be based off of your income. However, that note was only paying you back over the 5 months, the penalty period. So that is gone. That money has been paid back to the applicant and has been used to afford the nursing home bill. Your monthly payment then going forward is just going to be your Social Security and your pension. Now we've gone through the penalty, we've paid back all the money in that loan. Well, what did we protect? What do we still have? We still have that $50,000 gift that we gave to the beneficiaries that we were penalized for. The loan just covered during that penalty period. Okay, so even when you've done nothing before, when there's no exempt transfers that we can really make use of, you could still save about half of your assets, half of your countable assets, plus everything that is excluded when you're about to go into a nursing home. Again, the 5-year look back applies. We know that. We tell the county we intentionally made this gift. They say, great, pay yourself. We've given you the loan funds to pay, and you can afford your nursing home care. If there have been other gifts during the past 5 years, as often happens, people freely give gifts as they see fit. Maybe a son or daughter needed some money to pay for an attorney for a divorce or to pay for college for one of the grandkids. For better or for worse, that's considered a gift under Medicaid rules. We can look through 5 years of bank records before we submit an application to make sure that if there's these extra gifts in the past 5 years, that we balance our new gift and our loan accordingly to make sure you have enough of money to pay for the resulting penalty period. So it's a bit of a dance. We play around with the figures. The more income you have, sometimes can shift that balance from gift half, loan half to maybe gift 60%, loan 40%. So it really depends on what you have going in, what assets you have, what private pay rate in the nursing home, and what your income is. So I think it's important to remember that first and foremost, you need to have your estate plan. You need to have a will that lays out your wishes. When we engage in this type of gifting, what we're always going to be doing is looking at what does the will say. Oftentimes we're working with an agent under a power of attorney, and we are going to be trusting that individual as you have trusted that individual, otherwise you wouldn't have appointed them, to make sure they're carrying out your wishes. But we're also going to be looking at your will to see, okay, what did that say? What have they stated as their wishes? To make sure that if we give $50,000 to one child, that was your intention, rather than splitting that money equally. Or sometimes if there's disagreements between what one child thinks they should have and what another child thinks they should have, perhaps your will has laid out instructions, or we can tell by looking at your will that you would have intended for that money to go into a trust to take care of those children. So there's things we can look at to do the trust as well. Also imperative is that power of attorney. Again, as I said before, if the applicant is in a nursing home, they're not going to the bank and moving around funds. So you need to have somebody who you trust, who has the capability to move your assets around, and who has the authority to make gifts on your behalf. And that's an important section of the power of attorney that authorizes gifting, even to the agent himself or herself. That agent can then legally take your assets per the plan we've set out, per the instructions you've laid out in your will, and gift them appropriately in order to preserve them and get your nursing home coverage authorized. Even if you've done no prior planning, there are still options that exist, still things you can take advantage of. A lot of individuals will then ask, okay, well, what does this mean if I want to get into a really good nursing home? I don't want to be on Medicaid. And that's a very valid question. Obviously, everybody would prefer to stay off of Medicaid. Nursing homes would certainly prefer you stay off of Medicaid. And it's, unfortunately, getting into the right nursing home can be a little bit of an art. Sometimes you do have to put money up front, in which case we would also take that into account. But as you can see with the gift and no plan particularly, sometimes we can tell a nursing home, look, we've done some planning to obtain Medicaid, but there is going to be a penalty period because part of our plan involves making gifts. This means that during the penalty, the nursing home is going to get the full private pay rate. They're probably very happy with 5 months of guaranteed payment with Medicaid then afterward guaranteed than they are taking a client who might have a little bit of funds, might be able to privately pay a little bit longer, but they have no guarantee that that individual did no prior gifting in the past, such that when they run out of money, go to apply for Medicaid, that there's going to be a penalty period and no means to pay. So, you know, that can be very circumstance dependent as well as to, do we apply for Medicaid right away? Do we wait? It really depends on the nursing home and your own situation. That is crisis planning in very much a nutshell. It's very complicated and it's a lot of information at once. There are things that you can do in advance. Typically that involves planning more than 5 years before needing care. So, you know, it takes a bit of a crystal ball to engage in that planning. So most of the clients that we see are coming to us because someone is about to go into a nursing home. Now, I do have one question that just came through, and I do have one that I wanted to get back to. The question that came through is, I'm going to read it first and I'll summarize it. If I say I plan on going home. All right, friend, bear with me. Let me just read this. If I say I plan on going home from a nursing home, if I'm able, and my income has to go to the nursing home plus Medicaid. Please let me know if I'm not answering this correctly. When you, now, okay, so the question is, if I'm in a nursing home and I plan on returning home, and we've engaged in this type of planning, how do I make sure that my other home bills get paid? So Medicaid, once you're on Medicaid coverage, you're through a penalty period, all of your income has to go to the nursing home. Minus $50, you do get to keep $50 a month for probably one haircut or two. They don't actually allow you any funds to pay for mortgages, to pay property taxes, to pay anything like that. In that situation, you're banking on either selling the house at some point or renting it out so that the carrying costs are kind of covered, or using the money left in your resource allowance. Now, in the examples that I gave, I use big round numbers. We have $100,000, we give 50, and we loan 50. We want to try to protect as much as possible, so we'll typically leave you with the amount of your resource allowance, because that's automatically protecting at least $15,750. If you're going to a nursing home for a short stay, but you still need Medicaid coverage to cover that bill during that time, you're still going to have about $15,000 in the bank to go through that hopefully will last you during that stay at a nursing home. Okay, let's see here. Another question is, I'm going to repeat this. You said retirement accounts don't count towards the resource limit. What about RMDs? So a retirement fund does not count as an asset so long as you are receiving your RMDs. Okay, then what does that mean for the RMDs? When you're in a nursing home, that required minimum distribution that you're receiving from your retirement account is going to count as income. So typically what we will do is we will say, whoever's managing your retirement account, send us a distribution monthly. So they'll take the RMD, they'll divide it by 12, and they'll distribute that much to your bank account each month. That 12th of that RMD will become part of your income and will become then part of your payment to the nursing home going forward. Now, if it's a spouse receiving their RMD, again, it counts as income, but if we signed a spousal refusal, then we don't have to worry about contributing it to nursing home care or anything like that. So in most all circumstances, your RMD is going to count as income. It will become payment to the nursing home if you are receiving it and you're the applicant yourself. One thing to consider that I didn't touch on just because it opens the door to more questions, but when you are single and you're in a nursing home, the amount that you take from your IRA each year is actually almost doubled. Medicaid requires you to kind of draw from that account a little bit quicker. You still preserve the principal balance of that account, so it's still better to keep that as an exempt asset. You don't want to liquidate it, pay taxes, and then subject half of it to your care. You still, in almost all circumstances, are going to want to get that income, even if it becomes part of the bill, because the rest of the money in that account will remain exempt. The next question is, if someone dies while on Medicaid and is in assisted living or nursing home, does Medicaid take any life insurance proceeds or bank accounts to repay benefits Medicaid paid in the past? Very good question. So Medicaid or the county will make a claim against your estate. So if you've been on Medicaid for 3-4 years, receiving coverage, they've been paying towards your bills, your bill with Medicaid, let's say, is going to be rather substantial. But they can only make a claim on assets left in your estate. So what does this mean? Well, when we're doing our planning, what we're going to do is make sure that your $15,000 that we leave you with is in a joint account. When you pass away, the money in that joint account automatically belongs to the joint account holder. It's not in your estate. Your estate is anything that does not have a beneficiary designation or a joint account holder. So if we're talking about life insurance proceeds, you've named a beneficiary on that life insurance. So when you pass away, the beneficiary automatically gets those funds. It doesn't fall into your estate where you have to get the courts involved to name an executor and get assets distributed. So that's how we protect those resources and the benefits that you can receive from a life insurance policy, by making sure that they have beneficiary designations or joint account holders. Another question. If an individual is childless, can a loan be done with an extended family member? If the person passes before the loan is repaid, what does it says, what does the county come for it? So if there is no child, we've done loans to brothers, uncles, cousins, nieces, nephews. It depends on, do you trust this person? Are they financially comfortable such that we don't need to worry about them losing this money or them walking off with this money? We are going to want to make sure that it's the right fit and the right situation for your particular circumstances. If the person passes away before the loan is repaid, they have signed this note, which is legally enforceable. They have to repay this money back, or their estate will have to repay this money back. That's something we talk about when we're trying to decide who do we loan funds to. Oftentimes what we'll do is, if you're in a situation where maybe there's 2 children or a niece and nephew that you loan the money to, they're joint on that loan account that's holding the loan proceeds, so that if one of them passes, the surviving one can still continue making those loan payments. You can afford the nursing home. I think I'm out of questions, but I just want to go back to, and feel free to ask more. I think I still have time, but I just want to go back to the changes that are coming to Medicaid. So Medicaid covers nursing home care, which is obviously substantial savings. Medicaid also covers in-home aides. It covers assisted living, and there's some benefits you can get there, but a big part of my practice is getting in-home aides to come in either to an applicant's home, or to, if they're in an independent living facility, to come in and take care of them at home. It's very beneficial to some of our clients. Obviously, nobody wants to go into a nursing home. It is unavoidable in a lot of circumstances. But if we can set up a system where your aides are covered and paid for, and you're safe at home, then that's preferable in many circumstances. Medicaid will pay for those in-home aides. We have some clients on 24/7 care at home. Medicaid's providing the coverage. That can also be rather expensive at a private pay rate. We've had clients who pay $17,000 a month, $20,000 a month for in-home care. Currently, I could give away $1 million and then qualify for Medicaid immediately, as long as I'm then left with $15,750. I could then get Medicaid to pay for my in-home care. Nursing home care is different. Medicaid could then pay for my in-home care. It's called community coverage, where they pay for the in-home aides. That has been the rule up till now. What they're now saying is that you can no longer transfer assets and immediately qualify for in-home aides and in-home coverage. In changing some of these in-home Medicaid rules, The state looked at a lot of different ways to save money on Medicaid. Obviously, it's a big expense for the state, and there was a huge budget shortfall. So the Medicaid redesign team, without getting too much into this, looked at the possibility of eliminating spousal refusals or the possibility of counting retirement funds. Those were not enacted. They did not eliminate those options, and they are still the rule of the land here. Retirement funds are exempt. You can use a spousal refusal. The changes that they did enact mostly have to do with individuals' eligibility for in-home care. There is a 2.5-year look back. I don't know why it's 2.5 years, but there is for community Medicaid now. So you transfer assets and it's not an exempt transfer. There might be a bit of a penalty before you can get in-home aids. Quick question. If someone is already on Medicaid and in assisted living, can they still change the beneficiary on their life insurance or bank account from going to their estate to going to family members? Absolutely. So assisted living is a little different. It actually falls under the community Medicaid rules and not the chronic care Medicaid rules, meaning that you don't quite have to worry about the transfer penalty, or at least you didn't before these recent changes went into effect. So assisted living Medicaid should be kind of its own presentation in and of itself. That being said, if you're even in a nursing home and on Medicaid, you can change that beneficiary designation at any point in time. They can't stop you from changing it from your estate to a family member. It's not considered a gift. There's no actual value that you're transferring at that point in time because you're still alive. So you can make that change whenever. And I encourage everybody who is in a nursing home, who knows somebody who might be in a nursing home, to take a look at those beneficiary designations. Obviously, I don't mean to say go rampant and change everything. There are legal consequences to doing some of these things, but it's worth taking a look at, reviewing those beneficiary designations, and then, you know, reaching out to an attorney or somebody who's familiar with Medicaid and kind of going through some of those to see if they should be altered or changed. Now, I don't see that I have any other questions. I'm happy to stay for more. Christine, I think we're all set.
I don't see any other questions coming in either, but Kelly, I'd like to thank you for taking the time out this morning, providing a lot of good information. And thank you all for joining and asking some great questions. There will be a brief survey at the end of this, so please fill that out if you have time. Also, I hope that you'll join us next Wednesday at 10 o'clock for our next topic, Your Voice, Your Values, the Conversation Project at ECMC. And we have a comment, thank you for all your information. So
thank you. Thank you all for the great questions too. Take care. Thanks, Christine.
Thank you.
All right, bye-bye.